welcome to the first program using the fact situation that will be used for the remainder of the year. By way of introduction, there are a few facts that have been added or changed that we thought would be useful for you to know before the demonstration begins. The child Amanda has already been found competent to testify. However, in preparing her trial testimony, she froze, suddenly refusing to talk about it anymore with the prosecutor or anyone else. Her psychologist believes that this will be temporary or could very well last throughout the trial. The prosecutor decides that expert testimony to explain this and other aspects of her mental state and emotional problems would be useful in helping the jury understand them as normal reactions to stress rather than any inference of her untruthfulness. The state wants to use Amanda's hearsay statements to others about the abuse, whether or not she can testify. If she doesn't testify, these statements may be the only evidence of adult sexual contact with her. The prosecutor decides to offer additional testimony by the same expert on a new technique called the sex abuse legitimacy scale.
Your Honor, at this time we're calling Mr. Pat Cummings to stand.
Consider yourself under oath, sir.
Will you please state your full name for the record, spelling your last name?
Patrick J. Cummings, C-U-M-M-I-N-G-S.
Mr. Cummings, where do you reside?
I reside in Gig Harbor, Washington, 14002, 56th Avenue Northwest.
And what is your occupation?
I'm a certified mental health counselor and a licensed school psychologist.
Mr. Cummings, would you tell us a little bit about your background?
I received a master's degree in psychology from Eastern Illinois University in 1975 and practiced part-time as a school psychologist and also as a family counselor. In 1983, I became qualified as a guardian ad litem and have a private practice in Tacoma where I specialize in issues of working with children and families, guardian ad litem, divorce mediation issues. My specific interest and expertise in this case is related to my extensive work with families on differentiating the truth from fabrication in child sexual misuse cases.
How many patients have you treated during the course of your professional experience dealing with sexually abused children?
I have conducted over 200 guardian ad litem investigations and have conducted, of which a large percentage has, not a large percentage, of which a certain percentage have been related to the issue of child sexual misuse. In that category, I've had 25 to 30 cases of working with families relating to the issue of dealing with the legitimacy or the fabrication of sexual misuse. In treatment of children with sexual misuse, I have a practice that deals with that in relationship to a family therapy. I also run groups at the high school and conduct youth services to teachers and staff regarding the issues of sexual misuse.
Have you testified before as an expert?
Yes, I have.
Your Honor, at this time I would ask the court to find the witness, Mr. Cummings, as an expert in the field of child sexual abuse.
Your Honor, this is a pre-trial matter. I think the court should listen to the entire direct and the cross-examination before it makes that determination. I don't think we can do that as critical.
Proceeding counsel.
Mr. Cummings, would you give us some general background of child sexual abuse?
Well, the statistics about the sexual misuse vary considerably. The most recent study, 1986, which reviewed a number of studies on the area of sexual misuse, suggested between 6% or higher of young children have been victims of sexual misuse. There are certain signs and symptoms that are apparent in dealing with the diagnoses of sexual misuse, which are difficult to determine in these studies. For example, sometimes sexual misuse studies are doing only with children who have actually experienced penetration. Other times having an exhibitionist expose himself to you might have you fit in that category of sexual misuse. So there's some discrepancy in the actual numbers.
Can you give us some general factors, a few of these factors of signs and symptoms of sexual child abuse?
Yes, the immediate impact are anxiety, related symptoms, fearfulness, sleep disturbances, nightmares, somatic complaints, stomach aches, phobic reactions, at times fearfulness in males. Younger children often have regression behavior, bedwetting, thumb sucking, separation. Older children often have depressive symptoms such as running away from home. In more chronic cases, it can manifest itself in what's termed post-traumatic stress disorder, where children have panic attacks, painful affect, feelings of helplessness, night terrors, morbid fears that they will be re-traumatized. There is also, of course, physical symptoms associated with sexual misuse, trauma to genitals that a physician could speak more clearly about.
In your expert opinion, are these general factors generally accepted in the field of child psychology as indicators of sexually abused children?
Yes.
And how are these general characteristics of child sexual abuse used in the sex abuse legitimacy scale?
The sex abuse legitimacy scale is designed by a psychiatrist, Richard Gardner, who has taken the factors that are common in most of these scales, be they through most of the scales of research, and has clustered them in areas that would be highly suggestive that a child has been abused to less suggestive that a child has been abused. Gardner, in his book, has essentially done a review of the research and listed the factors that are common in most of the research, and then has organized them in an outline form to place them in a scale form or a profile form.
Would you give us an example of how the scale works?
The scale is divided into three segments. One, it is the child who alleges the abuse is one section. The other, and I'll be typically, it will be the mother, but the accuser. And then the third section would be the accused, essentially in this case, or in most cases, the father, stepfather, or boyfriend. Within each of those three categories of the three people, there is a hierarchy. I will say Part A, Part B, Part C. Part A are very differentiating factors. Part B are moderately differentiating factors. And Part C are differentiating criteria of low value, but potentially useful. And A, B, and C are weighted in that if a child or a mother or an offender receives an item positive in item A, highly differentiating criteria, that would receive a weighted score of 3. And B would be 2, and C would be 1. So there's a total scores that are possible.
Would you give us a few of the specific factors that are listed in one of these sections, A, B, or C?
Well, let me start with the child, and I'll suggest that a factor C, which is differentiating of low but potentially high value, would be a sleep disturbance. That certainly is diagnostically significant, but many children have sleep disturbances who have not been sexually misused, so it is rated as a 1-point item. Whereas a child who has extreme fears of retaliation by the accused would be considered a item that would be very valuable, that would be voted with 3. So if a child received an item there, that would a check positive there would be a score of 3 points.
Mr. Cummings, would you tell us about your evaluation and treatment of Amanda?
Yes, Amanda was brought to me by her mother her mother was concerned and about the disturbances that were apparent in Amanda's life. She was having some regression in school performance. She was also having a cluster of emotional symptoms that were very problematic and concerning. Secondary to her coming was the concern that the mother was ambivalent as to whether or not the child had been a victim of abuse, and she wanted to know if the symptoms she was seeing were related to the abuse.
Did you then meet with Amanda?
Yes, I did meet with Amanda and have had numerous sessions with Amanda, working on standard, I will say standard issues of treatment, of dealing with presenting problems of her fear and depression and anger, and also dealing with issues that I think are surrounding abuse issues.
Did Amanda tell you specifically about what happened to her?
Yes, she did. She initially disclosed that through a play therapy format, and was capable of articulating that she was violated by Doug. More recently, though, she has become rather closed and is not communicative, which I attribute to a stress-related response to her previous use that she went through.
Did you administer the sexual abuse legitimacy scale to Amanda?
Yes, I did.
And what score did she receive?
Out of scores can be reported a number of ways. Gardner suggests a point value, but also a percentage of the total. On Amanda's total score of 60 items, I believe she had 65%, which would be 39 items if I'm correct off the top of my head. So it would be a 65% score.
In your expert opinion, what exactly does that mean?
Gardner sets forth a general criterion for interpreting scores. He suggests that a score of 6 or below indicates that the sexual misuse most likely did not occur or is more likely fabrication. Whereas the higher the child score, the more likely the child is not fabricating, or that this is a genuine or bona fide case. He also suggests that it is highly unlikely that a child will receive a perfect score, that you are looking at degrees. He is suggesting that 50% is problematic. From 20 to 75%, there is a range of problematic. Specifically, he says a score of 6 or below would indicate that there is fabrication, most likely. Scores of 7 through 29 are inconclusive. However, the closer you are to 29, the more conclusive it is. And scores of 30 or above are highly suggestive of bona fide sexual misuse.
And Amanda fits in that category.
Yes, she does. With a score of 39, she's substantially above that cutoff.
Have you met with Amanda's mother?
Yes, I have.
And did you administer the scale to her mother?
Yes, I did. Amanda's mother received 11 out of 27 items. Now, these are not items. This is her weighted score. Just to simplify things, for example, in the items that are the critical items of Section A, she received 3. So 3 times 3 is 9. A weighted score, a total of 11 out of 27, which is 41% of the items, which is also a little less suggestive than Amanda's, but certainly suggestive that that this could be legitimate or a bona fide case of sexual misuse.
And on the basis of your treatment and evaluations of Amanda and on your evaluation of her mother, do you have an opinion as to whether Amanda has been sexually abused?
Yes, I do. From my treatment of the child, from the use of the sexual legitimacy scale, from the consultation with the doctor regarding the medical information, I concluded that she has been a victim of sexual abuse.
Thank you.
nationally certified school psychologist.
But I take it that you are not a licensed clinical psychologist in the state of Washington,
Correct.
right? You are not a doctor, you have not earned your PhD at this point, is that true?
Yes.
Now, it was an idea in the past, was it not, that children did not lie or did not fabricate about the issue of being molested or abused, isn't that true?
That's correct.
Now, that's out the window now, that idea, is it not in your profession?
It is, since 1980, there have been numerous studies that are dealing specifically with that fact, that where in the past children most always told the truth, now there is some suggestion that with television, R-rated movies, sexual education in school, divorce problems with changes in divorce laws, that there needs to be more caution in immediately drawing the conclusion that when a child discloses abuse that she has in fact or he has in fact been a victim of abuse.
In fact, it's generally recognized not in your profession, the profession of psychology, that in fact children can fabricate, they can lie about sexual abuse. Allegations, isn't that true?
Yes, some statistics would suggest that between 6 to 7% of the children who do report are not, there has been no validation of the abuse. That number is higher in cases of divorce and custody.
For instance, in divorce and custody cases, admittedly this isn't one, but what are the percentages? 40%, 50%?
Green in 1986 suggested, with a very small study, 36%. It has been, the range is usually in the 40 to 50%. It is said that there needs to be great caution when abuse cases are brought forth in a separation or divorce.
Now, you've talked about Dr. Gardner's sexual abuse legitimacy scale, and you based your testimony on it. Actually, the title of his book is The Parental Alienation Syndrome and the Differentiation Between Fabricated and Genuine Child Sex Abuse. Is that right?
Correct.
So the whole, it's recognized by Dr. Gardner in his promulgation of this scale that it is in fact possible for children to fabricate. Is it not?
Yes, it is.
Now, there's an odor of objectivity about this scale, sir. We've got numbers 39. Was that the score?
Yes.
For Amanda, and that's 65%.
Right.
And it sounds to me like with Gardner's criteria that 30 points you go to jail, 6 points you don't go to jail. 7 to 30, maybe you do and maybe you don't go to jail.
That would be a misinterpretation of the scale that Gardner clearly states. He suggests that this is just but one indicator that with other information, interviews, work with the child, medical information, would lend an evaluator to make a determination if it was legitimate, bona fide, or fabricated.
Well, this scale yields some numbers, and you gave us the number 39 and the number 65% with regard to Amanda. But the fact remains that most of their criteria require some subjective interpretation and some subjective determination by the examiner. Isn't that right?
Correct.
For example, looking at criteria that apply to the child you're interviewing. Number 1, is the child very hesitant to divulge the sexual abuse? Criteria number 2, fear of retaliation. Is the child displayed fear? Number 3, guilt. Is the child displayed guilt? 6, is the description of the abuse credible? All of these things require subjective interpretation by the examiner to come up with these objective numbers.
There's some clarification that needs on the scale, at the front of the scale, is a statement that the scale should not be used without the interpretations that are more specifically set forth in the book. The answer to the question is there is some subjectivity. However, just looking at the items, each of those items, there are great elaborations on the items of what would be considered affirmative or what would be considered positive or negative as far as meeting that criteria.
So there's some guidelines in the book, but you'd have to agree that as to virtually each item, there is at least some element of your own subjectivity that goes into your assigning of positive or negative responses and then creation of these numbers. Is that true?
Correct.
Now, there are a number of things. Now, you interviewed Amanda, child,
Yes.
correct? You interviewed her mother.
Yes.
Did you interview the accused, my client?
I tried to interview him because the scale suggests that there are many items that require observation of the child and the alleged offender.
Now, we refused your request, is that correct?
Yes, you did.
Now, under Dr. Gardner's criteria here, that refusal counts as a positive response on at least one of these scales, doesn't it?
Yes, it does. In the refusal of either joint interviews, refusal to take lie detectors, refusal to...
Well, let me come back to that in a moment, but there are a number of things, talking about Amanda and about her mother, the responses they gave, which tend to show, which meet the criteria of Dr. Gardner, which tend to show fabrication. That is negative check marks on the list. Is that true?
Yes.
Please tell the court what those are.
In the area of the child, and I will list these in section A, B, and C, or section A meaning these are the highly suggestive areas.
In other words, these are the items that are given 3 points.
3-point response.
These are the most important. Is that right?
Correct. There were 3 that she did not meet the criterion for. One is sexual excitation. Many times children who have been abused will have a hypersexuality, excessive masturbation, preoccupation. 2 would be...
She had none of that.
She had none of that. 2 is desensitizing play. Oftentimes in their play and play therapy, they will reject dolls that might symbolize the offender. She had some degree of that, but certainly not enough that I would consider that as meeting the criteria.
In other words, you had to check no on the box.
Correct. 3rd was the attitudes towards one's genitals. Sometimes children who have been abused consider their genitals damaged. They reflect that in their drawings and also in their verbalizations. She did not do that.
And there were some of the other scales, the B scales, the ones that get 2 points, that were also negative, right?
In the B scales, there were 2. I will combine B and C. One is compliance. Sometimes children who have been abused, especially long-term, develop a very compliant pseudo-maturity. Others will have, the other area would be a sense of betrayal. They lose faith in their mother as the primary protector, and they feel betrayed. She didn't meet those 2 criteria.
Now, as to the mother herself, there were also items where she didn't meet these criteria, where there were negatives. Is that right?
Correct.
Could you tell the court what those are?
In the manner in which she disclosed, the initial scenario was suggestive that the manner in which she disclosed would be one. Initially, she did not initially downplay it, but she acted immediately on that. There was some hesitation in the way in which she disclosed, but generally fabrication, if one were telling the truth, there's often great hesitancy. The other lesser items, B or C items, 1 or 2 point items, would be a history of sexual misuse herself, abuse herself, an appreciation of the father-child relationship. In this case, it's the boyfriend, but children, the criteria would be scored if she had an appreciation that this child would be losing this person that was significant to her, and also a extreme passivity was not present, or a social isolation was not present.
Well, how about criteria number 4? I don't know if you touched on that. Criteria number 4 of Dr. Gardner's as to the mother, she does not want to destroy, humiliate, or wreak vengeance on the accused. That's so check. Yes, in this case, she said she wanted to sue him for all his work. Is that right?
Correct.
So that would be another negative response.
Right.
And that's one of the 3-point criteria, the very valuable differentiating criteria. Is that
Correct.
correct? Now, her score on the SAL, the sex abuse legitimacy scale, was just plain uncertain. Is that right?
No.
It's in the gray area. What was it?
It was in the higher end of the gray area, but not by, not.
It was in the higher end of the gray area, but it was in the gray area. Is that right?
Scores from 14 to 13. The closer they are to 4, the more likely the allegation was fabricated. The closer to 13, the more likely it took place. She had a score of 11.
In other words, as I think you put on your direct examination, she could be
Correct.
telling the truth. Is that right? Now, the last couple of points, you said that Dr. Gardner has put together his sex abuse legitimacy scale based on a variety of studies in the field about the criteria and the evidences that shed light upon the validity or invalidity of claimed sexual abuse. Is that right?
Correct.
But the scale itself, the SAL, to which we ascribe these numbers and these percentages, is strictly the creation of Dr. Gardner. Isn't that right?
Yes.
And that scale, as of this point, as a scale, as a measure, as a point system, has not been validated by any scientifically rigorous studies of which you're aware, has it?
That is correct. None of which I am aware, although he has a book due out that addresses some studies, but I am not aware, nor do I see them generally put forth in the professional publication.
He has a book due out, but it's not out.
Correct.
And so it would be fair to say that the scale, the SAL, upon which you scored these 39 points and these 11 points is not to put too fine a point on it, not generally accepted in the scientific community as being valid. Is that correct?
That is, I would say that is incorrect. The scale reflects a pattern or a profile of responses. The pattern or profile are generally agreed in the scientific community or the mental health community as existing and as being indicators. Now, you're talking about two things. One is the scale and the number. The other are the cluster of items and whether or not that cluster of items have in some way been organized.
Well, I didn't ask you about the cluster of items. I asked you about the scale of the number. You have to agree with me that the scale of the number is not generally accepted in the scientific community, whatever may be the case with the cluster of items or the general criteria.
Yes.
Now, the one last point. My client refused to take this or to undergo this interview process, and you've described that, and you've also said, in fact, he gets a positive response and therefore some points against him as a result of that refusal. But looking at Dr. Gardner's instructions, which is in the addendum of his book, How to Administer This Thing, he says, and I quote, would you agree with me, the scale is less valuable but may still be useful when the alleged offender is unknown or inaccessible for interview. True?
Yes.
So, taking his instructions, what he really says about this process is, that you've gone through, is that it may be useful. Now, going a little further, looking at the text of his book, he says the following, and correct me if I'm wrong, the proper utilization of the scale depends so heavily on the opportunity for joint interviews, so often emphasized in this book, that the absence of the alleged offender represents a serious compromise in the scale's proper utilization. Without that party, there is no opportunity for the child to be confronted with the accused's reputations, denials, and arguments in defense. The child's fantasies are then free to elaborate upon themselves, often with suggestions and elaborations provided by the accuser. Have I read correctly out of this book?
Yes, you have.
So what this says, if I read it right, and you tell me if you disagree, is that this study, or this SAL, this scale, which you told us is not generally accepted in the scientific community as a scale, is in the author's and originator's own terms seriously compromised as to its validity if you do not have the opportunity, for whatever reason, to interview the accused. Is that true?
Well, it's true, he says that, but he also says 2 pages later that the scale should not be used independently. You see, there are 3 scales: mother, child, father. We will say father, boyfriend. And he says 2 pages later that the examiners are warned that they should not use the scale independently of other data. Especially important are medical findings, and then he goes on. I think that Gardner, in many other places in his book, suggests that the scale, you will have problems with the scale if you are looking at a number. You will not have problems with the scale if you are looking at clusters or profiles of items that are suggested.
But he's talking about the scale, and to do the scale correctly, you need interviews with all 3 people. Is that right?
Optimally, yes.
And would you agree that he himself says that the validity of this process is seriously compromised if you cannot interview the accused for whatever reason?
Yes.
That's all.
Mr. Cummings, is it your opinion that although the scale itself may not be specifically accepted in the scientific community, that all the factors that make up that scale are generally accepted in the scientific community?
I would, yes, all, most all, yes. Those items are, some items more so than others, but they all are.
And your judgment and opinion today are based on those factors that are generally accepted by experts in the community?
Correct.
Does that conclude the proof? Argument?
The state recognizes that offering testimony on this matter will require that you take a careful review of the generally accepted nature of the science that underlies the proffered testimony. And we have briefed, in addition to Mr. Cummings' testimony, we have briefed on the literature references to review. Mr. Cummings' testimony is offered in a way which is offered to make use of the scale, but which is not limited to the scale itself. He specifically said that in his treatment and evaluation of Amanda, he observed her emotional state, reaction to the events, and could describe them for us and later for the jury in a way which helps the jury to understand what she did. Specifically, if she's not able to take the stand because of this mute response to the trauma of events, it will be critical for the state to be able to show that this response is well within the range of accepted responses to stress, and they use the term post-traumatic stress syndrome, and is not, in fact, itself specifically suggestive of any untruthfulness on the part of the recantation. And it's precisely this sort of purpose for the use of expert testimony on stress syndrome reactions that was approved by the Supreme Court in the state system. Other matters for which Mr. Cummings' testimony
Well,
may
if I
be...
recall Siskey right, the idea was to rehabilitate the witness once the veracity had been attacked. Is that the theory of relevance with this evidence?
That's the primary theory of relevance, because if she can't take the stand and her description of the events occurs only through the telling of others by the introduction of her hearsay statements to others, it's much the same as the defense counsel and Siskey saying to the jury, why would she go back to him if he beat her? Why isn't she able to tell us now? She was able to tell you in so much detail during an interview with you 3 months ago. In addition to that purpose for Mr. Cummings' testimony, the state intends to seek the introduction of various hearsay statements made by the child and 2 others regarding the events that occurred. One of them you heard today in the form of Mr. Cummings' testimony about what Amanda told him Doug did to her. We believe that.
Him being Mr. Cummings?
Pardon?
Him being Mr. Cummings?
Yes, he related her remarks to him about Doug putting his fingers inside her. And so that, at trial, would be admissible in our view under Rule 803-4, statements made to a medical professional for the purpose of his treatment or diagnosis of her. Her other hearsay statements were made to her mother, to Dr. Durrett, who would qualify under the same provisions with the Cummings, and to the interviewer for the prosecutor's office. Under the statute governing the admissibility of child hearsay statements made to others, a man who cannot testify, the state will need to show you that there are sufficient indicia of reliability accompanying the making of those statements, that there is corroboration of the occurrence that the statements are made to show. Those matters will be addressed when each of those statements is itself authored and is not a part of our argument today. In summary, the testimony of Mr. Cummings is helpful to the jury, primarily on the point of Amanda's now mute response to the events, and also to be helpful, we believe, to you in determining the admissibility of various hearsay statements she's made to others, because the very factors that were reviewed in his analysis of her statements are the same factors that are called upon for you to review in determining the reliability of the statements that were made to others.
Are you offering this to prove an element in your case in chief?
The state would like to offer Mr. Cummings' testimony as part of its case in chief, not only to show Amanda's mental state, but also to show the high probability of the occurrence of the events alleged.
That she was abused?
Yes. Thank you.
Counsel?
Good afternoon, Your Honor. My name is Jennifer Stevens, and we represent the defendant in this matter. The state has moved to admit the testimony of Mr. Cummings. His evidence is not admissible under Rules of Evidence 702 or RCW 9844-120. Also, the child statements to Mr. Cummings are not admissible based on confrontation, and if admitted, the defense requests a limiting instruction. Mr. Cummings' testimony should not be admissible for purposes of the jury because it lacks scientific reliability, and it does not assist the trier of fact and is unfairly prejudicial to the defendant. In Washington, expert testimony based on new scientific theories is admissible only if it meets the 5 standard. And under that standard, it must be admissible only if that theory or principle has achieved general acceptance in the relevant scientific community. Also, under the Washington Rules of Evidence, Rules of Evidence 702, expert testimony is not admissible unless it will be helpful to assist the trier of fact. Considered in this analysis is whether there would be a danger to the defendant of the evidence being unfairly prejudicial. In this case, the testimony should be excluded because the sexual abuse legitimacy scale has not been generally accepted in the community, and it poses an unfair prejudice to the defendant because the testimony concludes that the child has been sexually abused, which would give a strong inference to the jury that the defendant has committed a crime and is guilty of the crime. This case is similar to State v. Black, where rape trauma syndrome was not admissible because it lacked scientific reliability and it was unfairly prejudicial to the defendant. And it can be distinguished from State v. Sisti, where the battle woman syndrome was admissible because that had been admitted earlier and was generally accepted within the community and was used to show that, to explain actually why the victim acted in a certain way or did not respond in a certain way. There are several cases in Washington where expert testimony has been held inadmissible because it lacked scientific reliability and was prejudicial to the defendant. State v. Martin, State v. Wu, State v. Long, State v. Stewart, and also U.S. Supreme Court case Ford and v. Moyer, where a drug courier profile was not sufficiently reliable to be admissible. Mr. Cummings' testimony is also not admissible under RCW 9844-120 because it is not reliable and it is unfairly prejudicial to the defendant, increasing the likelihood of an erroneous conviction. Under the statute, the state must prove both indicia of reliability and the presence of corroborating evidence. And both must be proven independently, and the policies and purposes behind corroboration support the fact that this testimony should be excluded because the testimony is so highly prejudicial that it will result in erroneous conviction, and the purposes behind corroboration is to curb that risk and to lessen the fear that there will be an erroneous conviction. So the purposes and policies behind corroboration support that the testimony should be excluded. Also under indicia of reliability, it could not be shown because indicia of reliability is determined at the time the statements are made. And the factors that the court looks at are surrounding the circumstances at the time that the statement is made, such as whether the child has a motive to lie. Well, here the facts support that the child may have had a strong motive to lie because when her behavior started to change was at the time that Doug moved in, the defendant. And that could show that maybe she and her mother had been living alone prior to that time. And this could demonstrate a jealousy on the part of Amanda that her mother has now been living with her man and another person is added to the family. So the facts as far as indicia of reliability would not be met here either because that's to determine at the time that the statements were made to ensure that the statements are reliable. In conclusion, the testimony of Mr. Cummings should not be admissible either to assist the trier of fact under ER 702 or under RCW 944, 9844, 120, and also because it is highly prejudicial to the defendant. And the defense requests that his testimony be excluded.
Any response? You all get the rule. We got a lot to cover in 10 minutes. We won't even come close. I thought they did a good job. I'd give them a hand. I don't know everybody. I'm Dean Morgan. I've met most of you, I guess. I reminded a couple of my expert stories. I do this. I teach judges sometimes, so I've been doing this before. But I would have heard of lawyers getting up and asking experts questions like the prosecutor is examining the drug chemist in a drug lab case, in a case where they've sampled the defendant's urine and they're going to offer the urine sample, maybe a civil case or whatever. Anyway, the prosecutor says to the chemist on the stand, "Doctor, are you qualified to give a urine sample?" To which the doctor responds, "Yeah, I have been since early childhood." And there are a couple of other expert ones or at least witnesses who should be practiced. The plaintiff who takes the stand and her own lawyer is questioning her, and the lawyer asks, "Now, ma'am, what kind of doctor was that? Was Dr. Jones? You went to Dr. Jones. What kind of doctor was it that you went to? What kind of doctor was Dr. Jones?" To which the witness responds, "Well, I don't know, but you told me he was a good plaintiff's doctor." The testimony that we had here is offered for 3 or maybe 4 purposes. I guess 4 purposes. I thought I'd ask you. You all know as much about this as anybody in the world. Was one of the theories of relevance, and let's organize our discussion about theories of relevance. Was one of the theories of relevance, do you think, to prove an element of the statutory crime, i.e. that she'd been abused? Was that an element? Or was that a theory? Yeah, I think he said that at the end, didn't he? Did he try to dodge around that a little bit? Yeah. For some of you judges, if relevance were your only objection, would you overrule and allow? If relevance were your only objection, does it have a tendency of taking at face value to further one of the facts in the issue? Well, let's assume that it does. Would you admit it though? How many people in the room would admit the offer of evidence? Raise your hand if you would. Anyone? How many would not? Raise your hand if you would. Winskill did a good job. Huh? What's the real objection to letting it in to prove that the girl was abused? Scientific reliability. Were you satisfied with scientific reliability? In this kind of an offer of proof context, does the judge get to weigh the evidence on scientific reliability? Can the judge, if he wants to, or she wants to, say, I think the evidence preponderates in favor of scientific reliability? was his preponderance test in this kind of offer of proof? And the answer is yeah, sure it is. Do you think there's enough here where a judge could reasonably say, by preponderance of the evidence, I think this is the law. This is by preponderance, I think this is generally accepted society. Yeah. I don't know, maybe you could. How many? But you wouldn't, would you? I would. And I don't think anybody would, given the nature of the testimony. Was he able to say that it had been validated or replicated? Was he able to say that anybody accepted the scale, which, first, from a probative value standpoint, the thing that is catchy with the jury is the numbers, isn't it? The scoring, giving a 39 instead of a 6. Has anybody been able to validate the scale according to testimony? If we had most psychologists adhering to this, in other words, studies being done and published to most psychologists, and most of them accepting it and some of them using it, would we have a different picture? Sure. So we wouldn't admit it to show that she did it. Would we, and I'm going to skip the rehabilitation. Well, let me ask you that. His second theory, one I hadn't thought of, and I thought it was pretty ingenious, was that he sort of says that he doesn't want it to prove that the girl did it. He wants it to explain why she's absent from the trial. At least I think I got that right. Does that amount to rehabilitating evidence? Well, the Siskey case he's talking about is one where I was the trial judge, and what we did there was we had a woman on the stand who was alleged rape. She was going to be impeached, and significantly impeached, and we all knew that. And so the state wanted to call an expert to testify to battered woman syndrome in its case in chief. But the reason they wanted to do it in the case in chief was they didn't know if the defendant was going to testify or not. But they knew there was going to be heavy cross-examination of her and all of the state's witnesses concerning her credibility. In that case, we allowed the battered woman syndrome essentially to refute or to show why she went back to this fellow after the rape. That was the argument. She wouldn't have gone back to him if there really been a rape. And the battered woman person was going to explain that battered women do this all the time and it's normal behavior during this kind of syndrome. In the Siskey situation, to rehabilitate after she's been attacked and lying because she went back to the guy after the rape, would you allow that sort of battered woman syndrome testimony? Supreme Court did. That went to the Supreme Court, and they said, yeah, that's okay. That there was enough evidence of reliability, of scientific reliability, and there was enough relevance on rehabilitation, and not to show she did it on rehabilitation. Here, if I understood the defense response on the rehabilitation argument, it was that this evidence gets no farther on rehabilitation than on an element of the statute, because it's just as scientifically unreliable on the rehabilitation as it is to prove it did. Do you buy that?
On the scale, not the cluster.
Sure. On the scale. Yeah. Now, what would you allow the cluster without the scale?
Sure.
Okay. How many would allow the cluster without the scale? A few more. How many would not? Okay. Well, I didn't think of that. I didn't. You know, that's a possibility, I suppose. But anyway, I don't think this would, at least the scale wouldn't come in on the rehabilitation. How about the 9A44? And you almost need this. Pass this around. I don't know. It may not be time to pass that around. Because you need the statute in front of you. We have about 3 minutes. We're going to quit in about 3 minutes. But on the 9A44-120, you won't have time to really look at it. I forgot to hand it out when I got it here. What it says is that a child under 10, that if a child under 10 makes hearsay statements, those can come in under certain circumstances. 2 of which are that there must be indicia of reliability, and if the child is unavailable for trial, which this child is, there must be corroboration. Is the state here offering Pat's testimony in part to prove indicia of reliability under 9A44-120? You'll find that in sub 1 of that statute. 9A44-120 sub 1 requires indicia of reliability. In fact, I think you'll see those words there. Is the state offering this testimony to satisfy indicia? I think you were, weren't you? Or did you say you weren't?
For the purposes of the problem, yes, I know there's a problem.
Okay. He's saying he's offering it for indicia. Is he also offering it to corroborate? Yeah, he is. And the corroboration's in element 2. You look at, in the statute, look at 2B, I think it is. That 2B? Yeah, look at 2B in the statute. So we have 2 different ideas there, indicia of reliability and corroboration. Is this evidence if we were to, well, is this evidence from the offer of proof from the site probative, or can it be used as an indicator of reliability? Let me ask you to assume that we do find it scientifically reliable. Can you use it as an indicator of reliability in that case, if it's validated and replicated? United States, well, for purposes of the confrontation clause, the United States Supreme Court has said no, it can't be used as an indicator of reliability if we're talking about hearsay statements offered through mom. That's going to be a little complicated. But one of our problems here is that they're offering this to support the hearsay through mom, right? The hearsay, the issue of reliability for purposes of 120 and for purposes of confrontation clause are those factors that surround the making of the statement. You can't use extrinsic evidence. You can't use the defendant's confession or doctor's exam as an indicator of reliability. Under 120, in our state case it says you can't under 120, it's Ryan in 103. Nor can you use it as an indicator of reliability under confrontation. And the case for that is Idaho versus Wright, a year and a half ago, from the U.S. Supreme Court. Can you, though, use this evidence, assuming scientific reliability? You might not even have to that, but assuming reasonable reliability, can you use it on the corroboration of 120? Answer, yes. This kind of extrinsic evidence is exactly what you're looking for with corroboration. So with 120, this can be used for the judge in deciding whether the girl, assuming some degree of reliability, I'm not sure it has to be the dry test, but assuming some degree of reliability, the judge can use this in showing corroboration under 2B, which we need here. But the judge can't use it in showing the issue of reliability under sub 1 of that statute. And it will be wrong if he mouths from the bench if that's what he's doing. The last point was they're offering, I'll take 2 more minutes. The last point was they were offering the girl's statements to the doctor. Now, the 9A44-120 stuff is going to relate to the testimony of mom, who's going to take the stand and tell us what the girl told her after the event, okay? Which is the girl's hearsay, but moms are witness in court. Now I want to flip you over to the girl. There's still the girl being the declarant, the out-of-court speaker. But it's going to be Pat who's going to tell us what she said. She's in his office talking to him. And you heard her testify to that. He was going to testify to her statements about what happened. At least I think you did or would have in trial if you let this in. And he is, first of all, under the rules of evidence, is that okay? Yeah, under the rules of evidence it is. 803 sub A4, the medical diagnosis and treatment exception, specifically allows that now, even with a forensic doctor. And there are 2 good explanations of why that's true. One is in the federal advisory rules. The people that wrote the rules, 56 Federal Rules Decision 183, and you go to the part that deals with 803A4, and they tell you that this rule, although it would not allow a forensic doctor, although under common law, before the rules, you could not allow a forensic doctor to repeat out-of-court hearsay that was only given to him for forensic purposes. Now, the rule is intentionally expanded to allow the forensic doctor to repeat any out-of-court evidence given to him for medical diagnosis and treatment, even if that is forensic diagnosis and treatment, which is sort of a contradiction in terms. The rationale is not reliability. It's rather that the jury can't make the crazy distinction that would have occurred if you allowed the limited use of supporting opinion, but not for the truth of the matter asserted. So under the rule of evidence, then, under our present rules, what he says about the girl, what he says the girl told him would come in. But here's something I didn't really realize, I didn't really focus on until today when I was looking at this hurriedly while they were at the conference to check with Idaho versus Wright. But Idaho versus Wright is a case that every trial judge ought to read with care. It's really important in all child abuse litigation. Also, if you're defense or prosecutor, you really need to read it with care. 1990 U.S. Supreme Court, 111 Lawyers Edition 2nd. And the point that I picked up in there that I hadn't picked up before is that the U.S. Supremes in that case disallowed on confrontation ground the kind of testimony of a young female declarant to a doctor that we ordinarily routinely allow under our rules of evidence. And they said no dice under Idaho v. Wright. What they said specifically, what happened there was the girl had gone to a pediatrician And she had told him what happened in the course of the exam. And then he came into court and was going to relate what she told him. Well, ordinarily, we allow that under the Penelope case, if you're familiar with Henry Penelope, War Washington II. And we don't usually pause very much with it. But what the Supreme Court did at Idaho v. Wright was they looked at how this doctor conducted the exam. This Dr. Jambura was his name. According to the U.S. Supreme Court, had conducted the exam suggestively. Had suggested to the girl what he wanted to hear, at least in the eyes of the court. And so they said that on confrontation grounds, it doesn't have enough condition of liability to qualify. So there may, Idaho v. Wright may, and I want to qualify this in one respect here just a minute, but Idaho v. Wright may provide a constitutional override to the usual application that we give to 803A4, and I at least wasn't aware to watch out for that until today. If your defense attorney makes a good argument anyway. The last caveat I would give, though, is that Idaho v. Wright might be distinguishable. And the reason is that in Idaho, I don't know why they did it this way, but they did not admit the girl's hearsay in Idaho v. Wright under their medical diagnosis exception. They admitted it under their catch-all or residual exception, which is, in their state, is the same as the federal catch-all. If you're in federal court, you know about Federal Rule 803 sub 24 and 804b5. But those are the catch-all provisions. Idaho had those catch-alls, and the Idaho judge and Supreme Court both used the catch-all provision to let in this doctor's repetition of the girl's hearsay. The thing about that is the catch-all is not a firmly rooted hearsay exception. So when they are looking for particularized indicators of trustworthiness, or particularized guarantees of trustworthiness, as they call it in Idaho v. Wright, they're using a non-firmly rooted hearsay exception. If you're a prosecutor, the response in our state would be that our 803A4 should be termed a firmly rooted hearsay exception. I don't know if it really is or not. I don't know authority on that one way or the other. But the argument would be that it is, and then if you have a firmly rooted hearsay exception, then you don't need to look for the kinds of particularized indicators, or you don't even look for the kinds of suggestions that you had in Wright. That would be a matter of argument for the jury. So that's kind of where the child abuse litigation, I think, is complex. But where these people took you in their presentation was, is this admissible to prove she was abused? No scientific reliability. Is it admissible to prove that she's not lying, or that she's not? Is it admissible to explain why she's not in court? I don't know. I have my doubts about that, but I haven't thought about it enough. 3, can you use it to, or can you use this to corroborate the girl's hearsay that's going to be offered to her mom? And the answer is yes under corroboration, no under admission. And finally, can you use what the girl told the doctor for its substantive, for its truth, for substantive purposes? Under the rule is yes. There's a real question under Idaho v. Wright. Have a good dinner.
Before everyone takes off, across the street, I have this attendance sheet that didn't go down this road and down here. Also, I think Jerry Costello has, Jerry Costello called the pupillage team leaders to mention that we wanted to have a real short get-together. If you wanted to stay a couple minutes here, about 2 to 5 minutes, we won't take off. You can do it right here. We'll go across the street on the way. And Jim Steiner, Judge Alexander asked if